Hi, my name is Lisa Cummings, and today I would like to share with you some information about qualified domestic relations orders and some frequently asked questions. Before I start on that information, first I would like to give you a little bit of information about our firm. I work with Cummings and Cummings Law. We are a full service law practice and we serve business owners, executives, families, as well as individuals who have tax, retirement plan needs, business planning needs, and a little bit more information about myself. I have worked through my career typically with large corporations as well as individuals, focusing specifically in the areas of benefits and retirement plan benefits, as well as compensation and executive compensation. Now, I would like to share with you some common QDRO situations as well as frequently asked questions. Before I start that, I wanted to give you a refresher about what a qualified domestic relations order is. Sometimes you may see the acronym QDRO. That simply stands for Qualified Domestic Relations Order. A qualified domestic relations order is a legal order which is used to divide retirement benefits in a divorce situation. The individual who owns the retirement plan account is called the plan participant in the QDRO document, and the individual to whom a portion of that retirement plan account will be awarded is called the alternate payee. A qualified domestic relations order is required to avoid any early withdrawal penalties and tax issues. Federal law actually requires a qualified domestic relations order to divide that retirement plan account. This is an additional court document which must be filed with your divorce court in order for the retirement benefit to be divided between the spouses. And then once the court actually signs this separate qualified domestic relations order, then that document must be sent to the retirement plan, which itself must review the document, make sure it follows their rules, and then establish a separate account for the alternate payee. One of the questions that I've received from individuals who've consulted with our firm is, do I need a QDRO in my divorce if my divorce decree awards me part of a 401k plan? And the answer is yes. Federal law requires that this additional qualified domestic relations order, in addition to a divorce decree, before any portion of a 401k plan account can be divided between the spouses. The plan administrator cannot divide benefits based solely upon a divorce decree. This separate qualified domestic relations order is mandated under federal law. This is an additional order that has to be signed by the divorce court and also must be approved by the plan administrator of the retirement plan. Once the court approves and then the plan administrator approves of this document, only then can the retirement plan account be divided. And the next question is, how long does it take to complete a qualified domestic relations order? Typically, this can take between 2 to 6 months, depending upon the retirement plan's procedures, the court's timeline, and the cooperation of the two spouses. Your divorce attorney may know how to prepare these QDROs. If your divorce attorney does not know how to prepare these QDROs, our firm can prepare the QDRO and provide that to your divorce attorney for filing with the court. Typically, it takes a very short period of time to draft the qualified domestic relations order, so the actual document can be prepared within a couple of weeks by our firm. The time that it takes for the court to review the document once it's filed with the court, and then the plan administrator to review the document again and then divide the account, that's what takes up those additional months of time. Another question is, can a QDRO be prepared after the divorce? And the answer is yes, but delays often create serious risks. For example, if the plan participant dies, retires, or withdraws funds before the QDRO is entered, the benefits may be lost. The sooner you seek a QDRO following the divorce, or even during the divorce proceedings, the more successful you will be in dividing the retirement plan account. Another question that I have received is what types of plans require a qualified domestic relations order? A qualified domestic relations order is required to divide employer sponsored plans such as 401k accounts, pensions, and 403bs. IRAs are divided by the divorce decree itself, not a QDRO. So if you are concerned about dividing only an IRA, then you do not need a QDRO. However, as long as that account remains within the 401k plan itself, or a pension or a 403b plan, then you do need a QDRO. I would like to note that federal retirement plans require yet a different court order, which are not QDROs. A pension under the Civil Service Retirement System, CSRS, and the Federal Employees Retirement System, FERS, requires a court order acceptable for processing, or COAP. That has to be filed with the Office of Personnel Management, a federal governmental entity. Another type of federal retirement plan, which requires yet a different court order, is the Thrift Savings Plan. The Thrift Savings Plan requires a retirement benefits court order, or an RBCO. For more information about QDROs, please visit our firm site at www.qdro.law or send me an email. My email address is lisa@cummings.law. Thank you for joining today. Bye-bye.